Good evening, everyone. Welcome to the fourth and the last session of this third day of the India ADR Week, organized by the Mumbai Center of International Arbitration. We'd like to express our gratitude to Link Legal and the Lagos Chamber of Commerce International Arbitration Center for hosting this event, or for hosting the session. We have a stellar list of speakers today, but let me introduce the topic. Today, this session would be devoted to discussing the manner in which we resolve disputes in the construction industry specifically, and we're looking at the perspectives from both India and Africa. We have a stellar list of panelists and speakers today, so just let me take a minute to introduce all of them to you. First off, we have Mr. Anand Srivastava. He's a senior partner with Link Legal. He's qualified to practice in both India and the state of New York in the United States of America. He's recognized as a leading practitioner by Legal 500, Chambers, IFLR, to name a few, for practices in aviation, projects and infrastructure, corporate M&A, and of course disputes. We also have with us Mr. Atul Sharma, who's the managing partner of Link Legal. He's a chair of the Aviation Committee of the Indo-Pacific Bar Association and a regional president of the Indo-American Chamber of Commerce. He has over 40 years or more of 40 years of experience in corporate litigation arbitrations. Of course, Mr. Sharma is recognized as a star and elite practitioner by publications such as Chambers, ALB, Legal 500, and he is definitely, as has been recognized, among the top 50 legal icons in India. We have Mr. Nusrat, who's the co-managing partner of Link Legal. Mr. Nusrat has been the Chevening Scholar in his day, specializes in international arbitration and dispute resolution. For the past 3 consecutive years, Mr. Hussain has been named as a top 100 lawyer in India by the IBLJ. He's won the Dispute Resolution Lawyer of the Year at the Legal Era Awards in 2019 and 20. We have Mr. Ngo-Martins Okonmah, who's a senior associate with Aluko and Oyebode, and he's a member of the International Arbitration Group of the firm. He also works in the energy and oil and gas and power infrastructure practice. He's been an arbitrator and a counsel in a number of international arbitrations seated in various jurisdictions under the rules of eminent arbitration institutions like the ICC. Finally, we have Mr. Funmi Iyayi, Ms. Funmi Iyayi, who's the managing director of the Lagos Chamber of Commerce International Arbitration Center. She's worked as the general counsel of the Lagos Court of Arbitration. She has been the CEO of the center in 2000. She joined as the CEO of the center in 2018 January, and then became a board member in December 2018. She is a member of a number of arbitration institutions across Africa and has been actively involved in disputes across the region. We are grateful to have all of you here with us and speaking to us today. Before we begin the session, we will have Mr. Sharma and Ms. Iyayi address us briefly. With that, we will hand it over to Mr. Sharma to begin his address.
Thank you, Paresh, for introducing us. This is a very interesting session because if we look at the gamut of the construction disputes, they are substantially different from a normal commercial dispute. And the obvious reason is that a project covered under a construction contract or a multitude of construction contracts is going to last for a few years, maybe sometimes we know of a decade as well. Of course, for various reasons. And the multiplicity of reciprocal promises covered not under the same contract, but a large number of set of contracts makes it more complex. Now, if we look at a normal commercial contract, you are only talking of a breach or two. All attendant facts are in support of the breach or in opposition of a breach which has happened at a point in time, or maybe at 2 or 3 points in time at the most, because there could be multiple obligations arising out of the same contract. But so far as a construction contract is concerned, you can never have a point in time where you can say that the contract has been breached. The reason obvious is that because of multiple obligations and a continuous nature of a construction contract, there could be large number of distinct sets of facts which could impact the progress or otherwise of the project. And therefore, if we look at the nature of typical claims which are arising under a construction contract, the complexity is at two levels. Firstly, the heads of the contract, the typical heads of contracts under a construction contract. The second, of course, is with regard to the technical aspects which underlie the entire set of facts which are the basis on which or for adjudication of a construction dispute. And that is precisely the reason construction law is in itself a very specialized field. You can't have a commercial contract as a subject matter of an arbitration, where you can say that a commercial law of arbitration or law of a particular commercial nature is governing that arbitration. But in the context of a construction dispute, you can very well say that construction law per se is a branch of arbitration. You could have obligations which do have the role and interplay of other commercial statutes, for example, SEBI, you could have, but the underlying determination is essentially substantially under the contract law, the Contract Act. If you look at the technicalities that are involved, when we are talking of a construction contract, we are talking of delays. We are talking of causative events which lead to the dispute. Those events can be concurrent, sequential, and even parallel. So there is a concept of parallelism in construction disputes. You need to understand the baseline programming, the float, the critical path, the pacing, the acceleration. Now this is so far as, only illustrative or few illustrations of the technicalities that are involved in a construction arbitration. If you look at the heads of claims, essentially there could be, mainly there are disputes arising out of delays, but then there could be subsets of delays as well, because you can have a delay to completion, delay to progress, disruption, claims on variation, overheads, profits. And for example, I'll give you a simple illustration. When you're determining the claim in relation to overheads, when you come to the head office overheads, you need to be very clear as to what is the basis on which you're going to get this claim. Is it going to be determined by a Bircher's formula or Amden? And likewise, there are a large number of concepts. You need to be very clear as to what is the basis on what manner you are arriving at the reasons for delay. The delay analysis in itself is a big science which has evolved over the years. So considering all these factors, construction disputes are substantially different from the general genre of disputes. So this is a genre by itself, which requires not only technical competence, but also understanding how the interplay between the technical side of construction and law happens. And in fact, there is so much of jurisprudence which has evolved so far as the technical and techno-legal aspects of construction disputes are concerned, that a large number of it has come to be recognized as standard jurisprudence governing these disputes. So far as the general jurisprudence is concerned, because most of the contracts contain arbitration clauses, there has not been a large amount of jurisprudence which has evolved, particularly in India, from a court side on the merits of the matter. That is also because the grounds of interference have been, squeezed. So therefore, a large amount of your ability to succeed in an arbitration is substantially dependent on knowing the nuances of the technical nuances, having a bearing on the legal interpretation of the contracts, as I said, whether it is in relation to the technicalities of the nature of the claim or the specifics of the facts governing, each event which has happened on the site. And of course, it is compounded further by the fact that when you're talking of a construction dispute, you're not talking of only one contract, you're talking of subcontract, you're talking of delays attributable to other contractors. So there's a large number of issues which are involved, and therefore we need to have a very different approach to an arbitration under the in the construction space. So I think with those opening remarks, I'll hand back to Paresh, and then of course we can have Funmi coming in.
Thank you, Mr. Sharma. That was a fantastic.
We're very keen to hear her.
Yes, thank you, Mr. Sharma. That's a fantastic synopsis of what we're going to discuss about. I'd like to, of course, call upon Ms. Funmi to share her address with us. Welcome, ma'am.
Thank you, Paresh, and hello, everyone. Considering it's an international arbitration, I think it's safe to say good morning, good afternoon, and good evening, depending on where you are. It's actually midday here in Lagos, and I understand it's about evening in India. And then for people joining us from everywhere else, hello. So as introduced, my name is Funmi Iyayi, and I head the Lagos Chamber of Commerce International Arbitration Center, which popularly called LACIAC, that's the acronym. So I would basically just want to spend a few minutes speaking about who we are, introducing our institution to you, because I imagine that this may be the first time you're hearing about LACIAC. If you just give me a few minutes of your time, I'll just quickly run through who we are, and then we'll get into the panel session. So LACIAC, as an institution set up by the Lagos Chamber of Commerce and Industry, which is one of Africa's oldest Chamber of Commerce. It's over 100 years old. And the vision in setting up LACIAC is to provide what we call tailor-made dispute resolution solutions to businesses, whether local or international, across all spectrums of claim, whether it's a small claims, medium or large scale. And though it's called the Lagos Chamber, it's by no means a Lagos or a Nigerian institution. We're actually global, and the LACIAC rules can be administered globally anywhere in the world. We have a keen focus on Africa, and we promote African seats in administration of dispute resolution processes. With respect to the topic of today, construction, we do have rules that, Mr. Atul was just mentioning how peculiar construction disputes are from, general contractual disputes. And LACIAC has adjudication rules and expert determination rules that, are focused on construction contracts. In addition to that, we of course have our arbitration rules, which are an adaptation of the UNTITLED rules and also the ICC. We have a mediation rules, and we're actually one of the only institutions on the continent that has a portal for online proceedings. And when I say online proceedings, I'm not referring to just virtual hearings, but got a portal on which parties can commence and conclude the entire dispute resolution process virtually without cost for any physical or paper communication. As I mentioned, we have a keen African focus. We also adopt a court system very similar to the ICC. So the LACIAC court monitors and scrutinizes awards, and the members of the LACIAC court are by no means, they're international arbitrators from all over the world. I actually encourage everyone to visit our website to find out more about us. For practitioners that are here with us today, please could engage me, or like I said, find out more about LACIAC on our website or on our LinkedIn page. We hope that you'll be able to advise your clients going forward to consider, inserting LACIAC clause, especially for their Africa-related business. It's a real pleasure for us to be here today. We believe very strongly in collaboration, and we're happy. I've had a relationship with NITI for a while, and we're very happy to be participating in the India Arbitration Week. My colleague Ngo-Martins and I, Ngo is part of our management team, in addition to being a senior counsel in one of Nigeria's foremost law firms. And as we go into the panel session, he will be answering questions, from a counsel's point of view, and I will pretty much bring an institutional perspective to the discussion. Thank you very much for having us here. It's a pleasure. Thank you.
Thank you, Funmi. We will now begin the session, and I'll hand it over to Mr. Nusrat Hassan, who's going to be the moderator for the session. Over to you, Mr. Hassan.
Thank you, Paresh. Thank you very much. Good evening, good afternoon, ladies and gentlemen. It's an absolute pleasure to be moderating this esteemed panel. And as you have all gathered, primarily the questions which I will pose to this esteemed panel is going to be from the perspective of construction disputes. I would just also like to welcome all the participants and request them to do put all your questions in the Q&A chat box, which you will find in the bottom of your screen, and we will take up these Q&A questions at the end of the session. In the event we do not end up, due to paucity of time, answering each and every question, we will respond to you by email. With that, let me start with my first question to Atul Sharma, and let's try and get his perspective of his over 4 decades of experience in the construction disputes. Atul, one of the questions that arises, we all know one of the pivotal phase in the process of an arbitration is choosing an arbitrator. So what qualities should you seek in your experience, in your wide experience, you should seek in an arbitrator for complex construction disputes?
Nusrat, as I said in the beginning, that construction disputes are quite unique in many ways. So what I would be very keen to understand when I'm interviewing an arbitrator would be his experience, not only as a lawyer or a judge. What I would expect to know from him is as to how many similar kinds of construction disputes he has been an arbitrator in. I'll give you an illustration. I was doing this Swiss chamber arbitration, where incidentally the clause said that and it was a dispute between an Indian and a German party, and the clause required that the arbitrator has to be neutral. And we interviewed about 7 British arbitrators. And the focus, of course, one was that, of course, large number of arbitrators do understand the contract law, the aspects of breach, of course, the principles of contract law, and also they have dealt with construction contracts. But construction contracts themselves are of such specialized nature. So this was a dispute relating to a windmill manufacturing, the unit manufacturing, and therefore we needed really somebody to understand the typicalities, including the licensing issues which would arise in licensing and technology like this. So it is these kinds of things which are very important, apart from the standard knowledge of law and the experience in the construction space.
What about question to you, Ngo-Martins? Is it a similar experience in Africa? Would you approach a selection of an arbitrator, or would you look for the similar qualities? Would it be normal to do that in your region?
Thank you, Nusrat, and good afternoon, good evening, everyone. You're absolutely correct. It's very similar experience with Nigeria and for the large part of Africa, which effectively is, you want to ensure that your arbitrator has the technical nuances to understand the issues at play. Atul had coined a very interesting phrase, which is the techno-legal aspect of construction disputes. So you want to ensure that your arbitrator understands the interplay between the technical issues itself and, of course, the legal issues that arise. So you're just not looking for purely an arbitrator with legal qualification, but someone that understands and who has been involved in similar arbitration disputes that dealt with a similar technical issue. I give an example. We just concluded a FIDIC-based Yellow Book arbitration dispute, where one of the key issues that arose in dispute had to do with the under-certification by the contract administrator. And the question had to do with a lot of interim payment certificates that were issued, valuing the extent of work that had been done. And because of the nature of technical issues involved, we wanted to ensure that we're not just getting an arbitrator that understood FIDIC contract itself, but also had that technical expertise to understand that process of interim payment, valuation by the quantity surveyor, the issue of the certification by the contract administrator, and that was the kind of expertise we're seeking in appointing an arbitrator. I mean, the other thing to add to that is, I mean, this is not specific to construction dispute, but you want to ensure that your arbitrator will have availability. One of the key issues we see, especially in some institutional arbitration, has to do with timely rendering of awards. So you want to ensure your arbitrator will have the time, because most experienced arbitrators usually have a lot of arbitrations they are dealing with and will have very little time. So you want to ensure they have that availability to deal with your dispute. Thank you.
All right. Thank you, Ngo-Martins. I think you've made the point, or it seems it's very similar. Yeah, I think you picked the right word by saying techno-legal. I think that seems to be the right word when you're looking at trying to choose the arbitrator, especially in construction disputes with that kind of experience. I think one of the issues specific to construction disputes, which is I think much more unique to in the construction world, Atul, is with reference to multi-party disputes. How do you approach an issue? What is your experience been in multi-party? Because you especially in construction, there are so many concerned parties, which is normally very different from the regular arbitrations. Probably different from a shareholders' disputes. So how do you approach that aspect? I think this is a complex issue, and we'd love to hear from your experience. What's been your experience?
Nusrat, you're absolutely right. See, the whole construction space has so many components. I'll give you an illustration. When you're talking of construction, you could also be talking of a PPP. So PPP will involve construction, operations, earning out of the project, and that will also involve financing. So now if you look at the multitude of contracts having interlinkages in terms of termination payments, in terms of step-down clauses, in terms of equivalent project relief, all those need to be intertwined very, very well. So therefore, but the difficulty is that it is not always that every contract will have an arbitration clause. Now, if you look at this typical illustration which came before the Supreme Court in Dura Folguera, now there was, with the same contractor or its parent company, which has issued the parent company guarantee, this contract was split into 6. It was in relation to a material handling contract on a port. Now, it was split into 6 contracts. Some were offshore, some were onshore. Now, the Supreme Court was stuck with the situation. It is the same project, but then they couldn't do anything about it. They had to say that because you can't club the international and domestic dispute. Now, compare that with what happened in chloro control. They said there may be each contract doesn't have arbitration clause, but there is a commonality. So what they said was you have to look at direct relationship to the party, to the signatory party, commonality of subject matter, composite transaction, mother and ancillary agreements, common object and collective bearing on disputes, composite reference will achieve the ends of justice. Now, this is easier said than done because it involves a lot of facts, a lot of obligations you need to see within those contracts. I had a very interesting example. I was to invoke a dispute in relation to a project which was awarded. Now you can speak about it because the dispute is now public. It's in public domain because the matter is now pending in the High Court. 34 is still pending. And here the road was to be built by a concessionaire, NHAI road, There were 2 state support agreements because the road was passing through 2 states, Haryana and Punjab. Now, if there is a breach by Punjab and Haryana of its obligations in relation to constructing an alternate route, so first you had to get it determined under the parent contract of concession from NHAI, and then go to states and invoke arbitration, which means 3 arbitrations. Now, I was stuck with a very strange situation. So I devised a methodology. I went to the writ court because state governments were all subject to writ jurisdiction. Got a composite reference made. And now the question arose, now there are 3 arbitrators. Who will nominate whom? So we were allowed to nominate one, NHAI nominate one, and the state governments were allowed to nominate one. So that these are, really creative solutions to be found in multi-party disputes. There's a lot we can talk about it, but I thought broadly, this will be the contours which you will encounter in multi-party situations. And of course, one more thing, so far as the institutional arbitration is concerned, there is always the rules will speak more about, joinder of causes of action, joinder of parties. But in India, which where the ad hoc rules, it's a difficult proposition.
Yeah, so
it depends on
that cue, Atul, I'm going to go to Funmi and ask her, how does her institution cover this kind of issue on a multi-party? Does it, do you have a specific, do you cover it specifically in your rules, or how does that play out?
Yeah, thank you, Nurash. And then just as Mr. Sharma had just said, yes, our rules have specific provisions for joinder of parties. And then, as I mentioned, we have our arbitration rules as well as our adjudication rules. And for construction disputes, adjudication is one of the more utilized rules for construction disputes. Now, under arbitration rules, parties are it's a bit rigid in the sense that the tribunal will only join a party if they're a party to the agreement, right, under the arbitration rules. But under the adjudication rules, on the other hand, there's a broader interpretation. So the adjudicator can join parties to an ongoing adjudication if the dispute is related to the dispute before the adjudicator. And then even when they are unrelated disputes, but then they are connected to the same contract, the adjudicator can join parties. So there's a broader perspective. Under adjudication, there may be separate disputes, but they arise from one contract, or there may be related disputes arising from different contracts, and the adjudicator has the discretion to join parties. The other thing that Mr. Sharma mentioned with respect to appointment of tribunal in multi-party arbitrations, for instance, is under our rules, the parties are typically just heaped in one. So all claimants are claimants, and they would have to make that decision as an appointment, and then all respondents are respondents. I think it's very interesting what he just experience he had, and what was done with respect to appointment of tribunal members. Having said this, where parties are unable to make appointments, even in a multi-party proceedings, the LACIAC court would then make the appointment for the parties using our list process. Yeah, so that's about it with respect to multi-party proceedings. Whether it is how parties can be joined in arbitration, which is you must be a party to the contract, or in adjudication, on the other hand, even if you're not a party to the contract, but then the dispute is related to what is before the adjudicator in terms of the contractual documents, the adjudicator has the discretion to join the party. And with respect to appointments, the tribunal would typically have all claimants, the multiple claimants, and the multiple respondents as single in appointment. Thank you.
Thank you. Thank you, Funmi. Anand, I have a question for you related to the earlier question with regard to multi-party disputes.
Yeah,
what is the effect of a back-to-back clauses in construction arbitration? I think this is, we find this issues arising, it's a common issue. What is your experience, and How have the courts reacted to this?
So it's an important point, Nusrat. Thanks. A back-to-back contract is usually a contract, where main contractor enters into a subcontract with its subcontractors on a back-to-back basis by mirroring the main contract between the main contractor and the employer. These conditions normally, would include provisions for equivalent project relief, which Mr. Sharma was saying. So the benefits of the main contract are passed on to the subcontractor, or issues such as the subcontractor gets paid under the subcontract when the main contractor gets paid under the main contract. Or we have seen cases where the liability of the main contractor to the employer is backstopped to the extent of the subcontract works, to the same extent under the subcontract. And our Supreme Court in the past, we have had decisions which are contrary depending on the the facts presented. So on one hand, we have had a decision from the Supreme Court where the Supreme Court has held that the subcontractor cannot claim from the contractor unless the main dispute under the main contract, which would include the claim of the subcontractor under the subcontract, have been decided, or its entitlement to pay is also not originating, unless any compensation in excess of the claim adjudicated under the main contract is there, and to that extent, what is payable or allocable to the subcontract works would be decided. And this is a fairly recent decision, of course, in relation to the L&T versus Madan Lal Harbanslal Bhayan decision 2015. And on the other hand, we have had a decision where the Supreme Court, on a different set of facts, limited the back-to-back contract only to the technical conditions prescribed under the main contract, leaving the contractor harboring liability, basically, which means that while the obligation of the contractor to pay as sealed by the award in favor of the subcontractor is covered under the first arbitration under the subcontract, it would be sustained. The award in favor of the main contractor in the arbitration between the employer and the main contract would possibly be set aside. And therefore, you will find that the main contractor is left uncompensated and liable to pay the subcontractor from its own pocket. And this is again in the same year, in 2015, the Supreme Court in Ircon's decision basically, held the same thing. And it would therefore depend on how the arbitration agreement is drafted and how the contract conditions are drafted. Because both views, whether that a contract and therefore arbitration proceedings are to be held on a back-to-back basis, or they are two separate matters, Order 12 Rule 6 applies, you cannot they are two separate contracts, rights gets decided separately. And a very important point, I think, after 2015 that has come in is in Section 8 of our Arbitration Act, the words party to the agreement have now been followed by the words or any person claiming through or under them. And this is consistent, of course, with the international arbitration piece. And therefore, we are seeing that more and more, it is very important how you draft your clauses, especially the arbitration agreement. And because the courts are very clear, they could actually hold it limited only to the technical conditions and not the arbitration agreement per se.
Right, Anand. Right. Thank you for the detailed explanation. Ngo-Martins, you heard Anand speak how the courts have taken more or less both views. Is there any specific view in terms of in the African region in Nigeria? Thank
you very much. It's quite a very interesting perspective from what we see in India. In Nigeria specifically, the Nigerian courts are still have a very rigid approach to the issue of privity of contracts, basically. They typically want to treat the main contractor and the owner under the main contract itself, and then the subcontractor under the subcontract itself. So that principle is still very much the general rule that operates. Of course, there are some exceptions to that rule. I think in the specific context of this discussion, it's important to highlight that the same provision that Amma had mentioned in the Arbitration Act in India is also available under the Nigerian Arbitration Act, in which case there is a liberal definition of parties. The parties is not just the signatory to the arbitration agreement, but the parties also is one who is claiming under or through a party in, to the arbitration agreement. And interestingly, there's a recent Nigerian case law on that point which involved the parties to the arbitration agreement were actually JV partners, and the JV entity itself was not a named party to the arbitration agreement. And when an award was made, the award was challenged on the basis that the award was made against a non-signatory. And so what had happened is that the Court of Appeal enforced the arbitration award and rejected a challenge to nullify the award on ground that the award was made against a non-signatory to the arbitration agreement. Interestingly, the rationale, because the court had held that the tribunal was justified in extending the arbitration agreement to a non-signatory because the evidence showed that the non-signatory performed the obligation under the contract on behalf of the project sponsor. The court was influenced by the fact that the non-signatory was a special purpose vehicle with no independent objectives of its own, set up specifically to perform the contract on behalf of the project sponsor. So I think the question then is, are you likely to see this kind of interpretation in a construction context? It's still open to debate. There's no clear judicial authority on that point. Of course, a possible argument that could be made is that the subcontractor had performed the works in his own rights under the subcontract agreement and not for and on behalf of the main contractor. That's basically what we see currently in terms of that issue in Nigeria.
Yeah, I think, this is very interesting. I think we could have spent some more time on this issue, but I think due to paucity of time, I'll move to the next question. That is interesting to know, Ngo-Martins, from your end. Now, once the tribunal has been formed, there are applications which come up, which raises the issues. One of the parties will raise jurisdictional questions. What are the jurisdictional questions which do come up you've seen in your experience, Atul, insofar as construction disputes are concerned?
So there can be quite a few objections to the jurisdiction. For example, non-compliance with the arbitration clause in terms of getting a DAP decision or getting a pre-arbitration mediation or conciliation invocation, accepted matters, res judicata, accord and satisfaction, exceptions of fraud. All these are standard jurisdictional challenges. But I came across a very interesting situation. In fact, there could also be a situation where there could be an overlap on the jurisdictional aspect as well as privity. Now, in a subcontracting situation, I confronted a very strange situation. I filed claims on behalf of a contractor, and the 100% of the contract was subcontracted to a subcontractor. Now, one question which was raised was the tribunal has no jurisdiction because it disputes what you are today raising are the claims of the subcontractor. Therefore, the tribunal has no jurisdiction because you must first establish that you have suffered a loss vis-a-vis your subcontractor, and therefore there is an intermingling of jurisdiction and privity. So these are typical situations, and then the question arose as to whether a claim which is premised on the claim of a contractor which has been executed by a subcontractor is it in the nature of indemnification, or is it in the, or it can survive only on a restitution basis? So these are typical questions which arise, but of course, we've got to deal with the facts of each case and arrive at, what could be the right approach.
Okay, that's really interesting. I'm going to jump over to you, Ngo-Martins. You heard Atul talk about what are the issues which do arise insofar as jurisdictional issues are concerned, insofar as construction disputes are concerned. What about in your region?
Yeah, Nusrat, thank you. I think there are similar types of objections we see across jurisdictions. I mean, I've been involved in two international arbitration very recently, where we've seen very. So I mean, in one of those cases, the objection that was raised, it's a FIDIC-based contract, and as you would expect, with the pre-arbitration steps that ought to be taken, an objection was raised regarding non-compliance with the correct contractual procedure. The claimant had gone directly to arbitration without complying with FIDIC clause 20.2, which requires reference to DAB. The respondent had an objection was raised, and the claimant had argued that the FIDIC clause 20.2 was not mandatory and therefore should not be enforced, and that if mandatory, the FIDIC clause 20.2 should fail for uncertainty because the parties had not specified the appointing authority in the contract. And finally, that the respondent had waived their right to insist on compliance with the FIDIC clause 20.2 clause. Of course, the tribunal rejected those arguments and upheld the contractual mechanism, basically insisting that you had to go to DAB first of all before triggering arbitration. Another interesting arbitration objection that I've seen very, very, very recently, and that's basically because of these flow down clauses you were referring to, Nusrat, where a subcontractor, without being alive to issues to the terms and obligations under the head contract, typically a flow down or a flow down or incorporation clause is inserted in the subcontractor, where the subcontractor agrees to be bound, is notified and agrees to be bound by the obligations in the main contract. So what had happened here was that when the claim was raised, when the arbitration was commenced, the respondent had raised the counterclaim on the basis of certain interesting set of rights, a set of clauses in the head contract against the subcontractor in relation to other contracts by affiliates of the main contractor. And when this was raised, the subcontractor had raised an objection to the counterclaim on the basis that the dispute in question did not arise under the arbitration agreement or were not connected to the arbitration agreement itself. That dispute is still very live and it's all ongoing, and the tribunal is yet to determine it. But that shows you the interesting the interesting issues that arise regarding flow down clauses or incorporation by references clauses, where all manner of obligations are taken on without fully understanding and appreciating the extent and implication of those sort of obligation in a dispute context.
Thank you. Atul, taking what Ngo-Martins just mentioned, what is your experience of the DAB, role of the DAB in a multi-tier dispute resolution process?
Nusrat, in the Indian context, if you look, the DAB has lost its relevance. Frankly speaking, I have a very funny situation which I am encountering. Now, it is a non-binding DAB decision, and the contractor has the employer. The decision of the DAB was against the employer, and the employer has given a notice of dissatisfaction. Now again, and what has happened is that the employer has, because I am not agreed as a contractor, so I can't invoke arbitration because there's a decision already in my favor. Now there's no mechanism within the contract wherein I can enforce that, because if he has given a notice of dissatisfaction, he needs to invoke arbitration, but he chose not to for about 6 months. What could I do? So I had to file again, go back to the High Court under 226, And now that matter is pending, we're seeking a direction to the, because in this case, fortunately, it was again a government entity. So therefore, we could ask the court to issue a writ directing them to initiate arbitration. So these are typical things. And in fact, DAB decisions, I had a similar, another experience in Bihar. I mean, notwithstanding it was a binding decision, payments were not made. Now, what do you do? So it is, again, very difficult situations. And DAB could be a very good mechanism to really put counter problems from a cash flow perspective. But unfortunately, it has not worked.
Okay. I think Martin, you've already dealt with the issue of DAB. So I'm going to jump to the next question. We are slowly running out of time, and I want to ensure that we can get as many questions answered within this group. I think one of the issues specifically in construction matters which do come up is the role of the expert. I think, in fact, if I'm not wrong, one of the questions that has popped up also is on the asking on the role of specifically experts insofar as construction disputes are concerned. I think probably experts have been around in India, which has been now a much more common phenomena. But in construction disputes, we've seen it from a very long time. Now, Atul, I'm going to pose this question to you. How important are the appointment of experts and engagement strategies in India insofar as construction disputes are concerned?
I think experts are, of course, very key component of a construction arbitration, undisputably. Now, after the amendment to Section 26, now the tribunal can also rely upon experts. But a very interesting question again came with, it in Indian context, it's very common for the tribunals to say that we want to go on a site inspection. Now, is the tribunal an expert? Now, I mean, there was an argument, and I said, look, there could be a view that the tribunal member, the arbitrators, should be sitting in the dock because they can't be doing a fact finding for either of the parties. So if they want to appoint an expert, they should appoint an independent expert, and that is not binding on them. So, I mean, these are typical situations, and experts do have a very significant role in a construction dispute, especially from the perspective of valuing claims and arriving at doing the delay analysis.
Right. Funmi, what about you as an institute? How do you approach the issue of experts? I think specifically in construction disputes, I guess there wouldn't be a dispute where you may not require an expert to come in as a witness.
No, so I mean, typically the rules do allow for parties to appoint experts, and then for the tribunal as well, actually, to appoint experts. So there's that liberty. The tribunal can appoint experts, which will, and then the cost of that, of course, will be borne by the parties. And then the parties are also at liberty to appoint their own experts. But for parties in appointing experts, it's really important that they sort of gauge not just how sound the expert is academically, but just the expert's ability to go through cross-examination, because that's something else that practically in an arbitration that you would see, you could have a sound expert, and then when he's subjected to hot topping, for instance, or even cross-examination, the expert is then not able to properly put forward his opinion, and then that would then become detrimental to the party. So I'll typically just say, once it's clear from the procedural preliminary meetings that parties are going to appoint experts or there'll be hot tubbing, you really need to be careful, in your appointments. Yeah.
Thank you, Funmi. So I guess your institute is very well equipped to sort of deal with this appointment.
Absolutely. And I mean, it's really the party's prerogative who they appoint. And then, like I said, the tribunal also has that prerogative to appoint, and so the parties may each have experts, but if the tribunal feels that, because the purpose of the expert, as we all know, is really for the purpose of the tribunal to understand those technical points, and if the tribunal is, and our rules allow that, if the tribunal is still not clear on positions, even with the testimony of experts, then they are allowed to go ahead and appoint one that will clarify issues to them.
Thank you, Funmi. Anand, over to you. I think one of the questions arising from the experts, I cannot not ask this question, is what is your view on hot tubbing? How efficient is it, the process, insofar as when you're dealing with experts? We know all hot tubbing is now one of the most talked subject in India, and now getting more popular.
Yeah. So firstly, Nusrat, I'm happy to confirm that hot tubbing process is now with statutory force in India. Our Delhi High Court rules in Rule 6, Chapter 6 now specifically provide for hot tubbing. After the Micromax Industries decision in April 2019. After exchanging written reports, as all of us know, amongst the experts, a joint statement of experts with the agreed issues and the not agreed issues is produced. And then basis such joint statement on the not agreed issues, there is hot tubbing with a directed discussion of the tribunal. And the tribunal, of course, moves issue by issue with the experts. And therefore, to speak to your question, hot tubbing has several advantages. From our experience, of having engaged in such processes in the disputes that we are engaged in, I think the most prominent benefits could be categorized in three buckets. Firstly, I think it leads to a less adversarial environment where the experts are less likely to maintain their extreme positions. As from what we are trained into understanding psyche. In a coalition setting where you meet the same people who reiterate the same position again and again, the position becomes extreme. And in cases where you are in a less adversarial situation, where you are between professionals, it is therefore a less adversarial setting than the traditional setting, and there is therefore removal of the experts from questioning by counsel until after all the relevant expert opinions have been espoused. And therefore, it is much, much easier to make concessions by the experts. I think the second benefit that I see is that the promotion of the independence of experts is a great value that is added by hot tubbing, because it separates the experts as an independent person from the factual evidence that the party retaining the expert has given, and therefore the expert can give his own views in a more free manner. And lastly, I think just because I'm conscious of time, it encourages representatives and judges and experts to focus on issues prior to trial and to clearly identify the issues of disagreement. And time at trial is therefore saved by this focus. And it is much more easier to, evaluate each disagreement before moving on to the next. So I think hot tubbing virtues are recognized, and of course, most of us practitioners favor it immensely.
Okay. Anand, thank you for that detailed reply. And I think it's really, we can appreciate how why hot tubbing has becoming more and more popular as a form to engage with the experts. I think I'm going to pose if we are running out of time, I have a few questions more in my bag, which I would love to pose to this panel. And I think, Anand, if you can probably also give us, throw some light on when the arbitrator is writing an award of his powers to award cost and interest. Insofar as, before I go to Funmi, maybe you can give the perspective from the Indian perspective, and then maybe Funmi can come in with her institute's perspective, especially on costs and interest. how.
Sure. So, Nusrat, as we know, interest can be awarded at all stages. I'll just take interest first. So whether it is pre-reference, pendentility, or post-award. And subject to party autonomy, which our section 31(7) provides, it opens with the words, unless otherwise agreed between the parties. The arbitrator is free to award interest, both pendentilite and pre-reference. However, if there is a prohibition clause or if the parties by agreement have agreed, then of course the words unless otherwise agreed between the parties comes in and the arbitrator cannot give interest. However, the position is significantly different because in post-award interest, there is no option for the parties to contract out of interest being awarded for the post-award period. And in case the award is silent, then there is a statutory rate of interest which is 2% higher than the current rate of interest. Now, coming to costs, I think India has adopted the traditional rule that the costs follow the event. I think that is now incorporated in our new section 31A. And therefore, unless the arbitral tribunal records for reason in writing, the general rule is that the unsuccessful party shall be ordered to pay the costs to the successful party. And the tribunal can decide, what costs are to be paid, the amount and when. And of course, the another important move is that the award of costs is now independent of the Code of Civil Procedure, process. And that these costs that are awarded have to be reasonable. And while awarding the costs, the tribunal has to take into account by mandate of law now, the conduct of parties, whether the parties have succeeded or not succeeded. Were there frivolous counterclaims raised? We have seen in the past, claims of in construction, especially 10,000 crores is raised. The arbitral award is 800 crores. And also the response of a party to a settlement, was a reasonable settlement offer refused. So all those things are now mandated in our law, and cost and interest is therefore now fairly, well decided, at least under the Indian legislation.
Thank you. Thank you for your rather lucid reply. Funmi, would you like to add to what Anand has stated?
So, I mean, with respect to our rules, it's not very different. What I would just first of all define what costs are, from a institution perspective. So it would include the cost of registration, the registration fee, the arbitral tribunal's fees, all expenses incurred by the arbitrators, travel expenses and every other expense, the experts' fees as well as expenses, whether it's experts appointed by the parties of the tribunal, and then cost of engaging legal counsel, and then the institution's fees and expenses. All this come under what we define as cost. Now, our position with respect to how cost is awarded is not different from what Anand had said. In principle, generally, the cost is borne by the unsuccessful party. However, the tribunal does have the discretion to apportion costs, based on the reasonable conduct of the parties. And then had mentioned, whether the party's response to a settlement offer. These are things that the tribunal will consider, in determining the reasonable conduct of the parties. And then also the proportion of victory, parties, whether the successful parties' victory is significant compared to, the loss of the other party. And those are the things that would typically be considered in awarding costs. Yeah, that's pretty much it. So it's not very different from what Anand has said. It's pretty much a similar position.
Thank you, Funmi. I did want to ask one more question to this panel on the enforcement, but I've been nudged by the organizers that we are just running out of time, and I want to deal with the question. So I was thinking to probably go to the questions directly, and a very interesting question is asked. I would probably prefer to have Atul's view and probably the view from Africa. Atul, can you hear us?
Yes, I can hear you because I switched off my camera. I was having some.
No problem. How attuned, because this is something which we've discussed before, how attuned are contracts in the construction industry to the specific issues which arise in construction dispute?
Now, if we look at the gamut of larger set of contracts in India, we have been trying to adopt FIDIC, but then we do violence to FIDIC, and to that extent, we need to hold our hands and ensure, because FIDIC is a standard, or maybe NEC, for example. NEC is a completely different animal. But FIDIC is a kind of contract which is essentially very fairly balanced. But the problem in public procurement is public authorities don't want a balanced contract. They want a contract loaded against the contractor. So I think it is very, very important that we have a standardized contracting regime. And somebody asked me this question, I don't know, just today itself, that do we have the CPWD and PWD provisions any more relevant, which were the old world contracts in construction? They were all pretty standardized. Everybody knew the animal and they precisely knew how it works. But since we are now move away from CPWD and PWD contracts, we have moved to FIDIC in big way. I think we should leave that as it is, because then you have a large support of international standards and practices which come to your rescue. So that is, I think, is not a very happy state in India so far as contracting is concerned.
Okay. Funmi, do you want to, or Ngo-Martins, do you want to take this question from your region?
Yeah, I mean, I'm happy to respond to the question. I'll use Nigeria as an example because the practices from jurisdictions to jurisdictions in Africa differ. In some African jurisdictions, you have some sort of standardized template for public procurement works, which you're meant to, which all public works the procurement needs to be done through those sort of templates, basically, except there is an exception that's given to you some other forms of, or some other forms of contract, maybe because the project involved multilateral development banks and financed by, and where they have those foreign financiers has a standard approach to giving out financing for project itself. But typically in relation to public works, using Nigeria as a case study, there's a standard contract that has been developed by the Bureau of Public Works, by which you use to procure works that are tendered through the Bureau. There are also other government agencies, because Nigeria is a federal system where you have various states, governments at various state levels and various federal parastatals. Those also have developed some form of standard template, but the reality is that many of these contracts are heavily lifted from the FIDIC, the FIDIC template, basically. So, I mean, the difference is maybe you would see one that is tailored more to the 1999 FIDIC standard form. There are some other ones that are particularly much older, and they borrow from much older books that were in place that led up to the 1999 FIDIC form that we know today. But that's exactly what we see. So typically, once you're familiar with those forms, you always understand some of those clauses and where they were borrowed from.
Thank you, Ngo-Martins. I have another question, Atul. This is, I think, a pretty interesting question, which, with your experience, it would be quite relevant. Your view would be quite relevant. The question is: are there provisions construction companies can include in their contract, especially with government clients, PSUs, etc., that can help them achieve speedy, time-bound settlement of grievances disputes? Separately, if there is any recommendation the panel would make to Government of India to enable this to happen, what would such advocacy be? What might you have the construction companies lobby with Government of India to enable the settlement? So basically asking, what are the things you should include in especially in the contracts with PSUs, etc., when they are coming out with the tenders ultimately? What should be there? Because I think that's a pain point, I guess, coming from a lot of construction companies.
Yeah, so Nusrat, see, if you look at the fundamental problem, which I see, is nobody is willing to recognize and come to an interim decision with regard to a claim. And that typically, if you notice, large part of the claims arise because of the failures of the public sector employers. And what happens is that the industry is starved of cash. It doesn't have cash flows. Even certified bills are not paid. So there should be now some standardized provision within the contract itself. Now, I'm not suggesting that you have an adjudication procedure as you have in UK, for example. So you have these technical courts, which will give you a decision in 7 days' time. If you accept it and implement it, it's fine. If you want to challenge it, you can go to arbitration, but then the whole cost will be to your account. But that is binding from a certain perspective. And therefore, what can be brought into is what I call as a troubleshooting clause within the contract, wherein in a situation like this, an interim decision is given, which is binding subject to the final outcome of that decision at any point in time, because that can put the contractor in cash. And that's where the industry can really sustain itself. And the biggest problem today in the industry has been it is cash stifled, because even the admitted the bills which are approved are not paid. And on the other hand, the employer is saying that I'm going to levy LDs because you have delayed. So these kinds of alternative solutions have to be found out. Otherwise, the industry is going to have a very tough time.
Thank you. That's useful. That's very useful. I think I'm going to just take the last question to anybody can come in. While quantifying damages in large infra project contracts often merely file auditor certificates to quantify the claims and do not file supporting underlying documents in support of its claim. So I think it's more, I think the question is more what happens, how does the tribunal treat this if the underlying documents, though there is a certificate of the auditor, I think there must be some personal experience of the participant who has put this question. What do you do with this?
Ngo-Martins, your experience, because
yeah.
I would only say this much, that you can't have 5,000 books of vouchers being produced before a tribunal. So it has to stop somewhere. So you could have illustrative vouchers, etc. But ultimately, there is a sanctity to the auditor certificate and the cost certificate which is issued. I'll hand over to Ngo-Martins to really give his perspective to this.
I mean, regarding certifications of these issues, it's not very clear to me in the context, basically, which is what I'm trying to fully understand. But just like Atul said, there are typically tons of documents in relation to this sort of things, and the contract administrator is oftentimes has to certify lots of things that are happening while the works are ongoing. Those basically those are things that are peculiar with the construction dispute itself. But I'm not sure I'm very clear in terms of, and I'm trying to locate. Unfortunately, I'm trying to locate the question on the platform, and I'm not quite very clear exactly what's the direction in terms and what's the context around it.
I think really the question is if one of the parties producing the auditor's certificate without the underlying documents, so should the tribunal accept the auditor's certificate as a quantification of damages and not really need necessarily go into the underlying documents?
Right. I see. I see. Basically, I mean, again, it depends on the language of the contracts. Basically, I know in some of these contracts, basically they say, well, the certificate is is a prima facie document certifying the content as it relates to those issues. especially where you have, I mean, I say this in the context of where, you know, interim works has to be certified on an ongoing basis, and the payment is required to be made on the basis of those certification itself. So usually it's the language that typically determine the language of the contract. I think it's an interesting question, because when you look at the FIDIC 1999 contract in language, as well as the 2017 contract, there's quite a distinction in the language in relation to a provision around certification for the purposes of payments. Basically, in the 1999 FIDIC contract, it seemed to suggest that, you know, payment has to be made based on, you know, the certification, and that's pretty much final on the question itself. But in relation to the 2017, my recollection, and maybe probably it's useful to check it again, but my recollection is that they are setting, in addition to the certification, the contract administrator who is issuing those certification need to be able to furnish certain documentation and provide certain explanation around how those conclusions were reached. And based on that, you know, it basically gives opens another, you know, scope for arguing and disputing the certificate itself.
Thank you. I think last question I'll put to you, Anand. The question is from Montek. You spoke about hot tubbing. Isn't that perhaps more useful when tribunals are well prepared on the quantum damages material and when issues can be distilled in a manner that allows both experts to engage on those issues properly? If overlap is limited, then hot tubbing may not be as useful. Any thoughts?
Yeah, so I think it's a good point. Thanks, Monte, for raising it. I think the process requires that the experts exchange their full reports, and then at least the process that we have followed in the disputes that we are engaging in, and then the experts sit together and prepare a joint statement. So I think a full exchange is the best way possible. I would agree with that. And at least that's what we have seen in practice. So I'm not sure how productive, or, you know, I'm sure like a partial or only some issues being hot tubbed would definitely have its own limitations. But what we have seen as maximum benefit is where you know, there has been a complete exchange of the reports, and a joint statement is prepared with the agreed and not agreed issues. So I would tend to agree with that, yes.
Thank you, Anand. I don't know if I have the time. MCI will have to tell me if I have any more time to ask the remaining questions, or we'd probably have to deal with them by email. Bhavni, is our time all over? Is it? Paresh?
Yeah, I think we are beyond the time today.
Okay.
I think for the remaining questions, if the participants have another question to ask, I'm sure the details of all the panelists and the speakers are with them through brochures, and specific questions can be sent across. I hope you can find the time to answer them.
Yeah, definitely we will answer those questions. You know, those questions which we have missed, we did not have the time to answer. But I would like to thank the panels for their insightful view. And before I hand over to you, Paresh, I'd just like to add the fact it is very interesting to have African friends from Africa, because just to give people some statistic, the least recent business standard has stated that the trade between India and Africa would be close to 117 billion. So there are a lot of infrastructure companies looking to explore in business in the African region. So this has been a very relevant, I think this is very relevant, and I'm sure we're going to have more discussions around this between these two regions. And I personally thank our friends from Africa for devoting their time and giving their insights.
Thank you for
Thank you.
Pleasure to be here.
Thank you to all the panelists and the speakers. It was great to hear a number of very, issues that we would only come across specifically in the construction disputes. And thank you for everybody from sharing these perspectives. At least at my end, I've taken some fantastic strategies from Mr. Sharma, taken some fantastic perspectives on hot tubbing from Mr. Srivastava. Funmi and Ngo-Martins, thank you so much for sharing the views from Nigeria and from the region of Africa. All of this will, of course, help all of the participants who were at some point of time, we were above 100 people listening and learning from this discussion. And that brings us to the close of the session today. For the participants and the attendees, please remember that the session was being recorded. So you will get the transcripts of the session at a later point of time. And just a reminder that today was just the third day. Tomorrow is another new day. Lots of fantastic sessions lined up. We start tomorrow at 10 o'clock in the morning, and the session will be on mediation in the coming years. So please do join in for that. And thank you everyone for the great learning experience.